All right, I'm going to go ahead and get started because we've got quite a bit to cover. Thanks everyone for joining today's CDT working group on the DoD Anthropic dispute, which has garnered a lot of attention, obviously, in the last week or two. And I think part of the reason this dispute is so interesting is because it's a discussion and debate taking place on multiple levels. In the most narrow sense, it's a dispute between Anthropic and the government in terms of the future of their contract, the potential damages to Anthropic as a company from money in terms of money and reputation, and it's a contract dispute. But obviously, it has broader ramifications. There are implications for the relationship between the government and private sector more generally. What does it mean if the government can designate a company as a supply chain risk or take other retaliatory action if it disagrees with the terms on which a company is offering product or service? And that's true not only for DoD, but as we'll talk about across the government more generally. And then obviously there are broader social issues at play. Should AI be used for mass surveillance on Americans or for lethal autonomous weapons? Who should make that decision and how do we make that decision? Should it be done in the context of a government contract dispute like this? Is it something Congress should be doing? But how do we, what should the answer for those questions be, and how should we determine the answers to those questions? So there are a lot of different levels on which this dispute is playing out, which I think is part of the reason it's both so interesting and has captured so much attention. So today, we're honored to be joined by a really stellar group of speakers. And just to give you a sense of sort of how we're going to do this, we will, although oftentimes our working groups are entirely Chatham House and off the records, just given the public interest in this issue, we're going to actually split it up. So we're going to start with opening statements by a series of a panel of speakers whom I'll introduce. And those are going to be recorded, and we'll post those on our website later. Once the opening statements are finished, however, we'll stop the recording and we'll move to a Chatham House so that both people in the audience and the speakers can engage in a frank dialogue that won't be public. And as with Chatham House generally, you can use what you've learned, but don't attribute what gets said to a person or their organization. So I'll remind you at the end of the opening statements that we're going to Chatham House, but for now, we're being recorded. So let me very briefly introduce our panel of speakers, and then we're going to jump in. We're honored to be joined today by Paul Lakis, who's the Executive Vice President for Global Public Policy and Government Affairs at the Software and Information Industry Association. Alan Rosenstein, who's the Associate Professor of Law at the University of Minnesota Law School, and among many other titles, a Research Director and a Senior Editor at Lawfare. Quinn Annex-Reese, who is here at CDT as a Senior Policy Analyst on our Equity and Civic Technology team. Jennifer Huddleston, who's a Senior Fellow in Technology Policy at the Cato Institute. And then finally, Jake LaPeroux, who's the Deputy Director of CDT's Security and Surveillance team. So with that brief introduction, let's go ahead and dive in. Paul, why don't I turn to you for you to start us off?
Great. Thank you so much, Samir and CDT, for hosting this event today on a very important issue. I am from the Software and Information Industry Association, and I have to begin with the caveat that the views of our association do not necessarily represent the views of each of our individual members. So I'm here today in part because SIA, along with three other associations, the Business Software Alliance, the Computer and Communications Industry Association, and TechNet, sent a letter to the White House in reaction to what happened, the designations that were made by Secretary Hegseth with respect to Anthropic. And the concern that we wanted to convey in that letter was that the designations, as they were done, have an impact on the broader industry. And specifically, there is an impact on the contracting part of the industry. There is an impact on the broader AI industry, and there's also an impact on the ability of the administration and the United States to achieve its objectives in the AI space, but also more generally around technology. And I guess I would start by talking about contracting. Congress has established a comprehensive statutory procurement framework over decades. It's been the product of considered legislative judgment, competitive bidding, and the rule of law are mechanisms by which the government harnesses the innovation of private industry. They're also something that essentially distinguishes the United States from command and control societies and something that really sets us apart. We are concerned that the process that was undertaken here has led the government to essentially blacklist a U.S. company from government work based on a pretext that it poses a security risk. And this is having implications already for the broader landscape. There's concern about an executive branch agency having the authority to convert a contract dispute into a supply chain risk designation, which is something that has been used rarely and is reserved for real national security concerns, and the lack of clarity that comes out of this. So this is something that is already having an impact on those companies that contract with the government and have uncertainty about whether the established procedures will be followed, and also for those companies that are engaged in contracts separately with Anthropic, given the scope of the potential order. I did want to point out briefly that one of the things that underlies the government's initiatives in the AI space to really promote U.S. industry domestically and internationally to encourage countries around the world to build on U.S. tech relies on the continued innovation and the policy environment that promotes innovation and a competitive landscape. And so, one of the things that we and the other associations want to convey is that this is having ramifications for the ability of countries around the world to really trust U.S. technology and be able to rely on and build on U.S. technology, which is essential in the race with China. So there's much more to say here, but the main point is really to convey that this is something that has, as we say in the letter, sent a ripple of uncertainty throughout industry. Thank you, Samir.
Great. Thanks, Paul. And now I'll turn things over to Alan.
Thanks, Samir, and thanks everyone for having me. So I'm going to just speak briefly about the legal authorities at issue, in particular with regard to the Defense Department's actions here. And I should say I submitted an amicus brief earlier this week in the Northern District of California litigation supporting Anthropic's position, and I'll be submitting an amicus brief similar in the DC Circuit litigation as well. So there are a couple of problems as I view it with what the government is doing here. So let's start with, I think, what is the most egregious thing, which is the secondary boycott that Hegseth was part of Hegseth's original announcement. Hegseth initially declared that Anthropic was a supply chain risk in a post on X, and in doing so, he purported not only to ban Claude from any government contracts, but he also purported to prevent any company that does business with the Department of Defense from having, quote, any commercial relationship with Anthropic. So not only would this reach Anthropic's, general enterprise agreements with a whole variety of Defense Department contractors on stuff that's unrelated to any Defense Department work, but it would also, in the extreme case, prevent companies like Amazon and Google and NVIDIA, all of whom, of course, do work with the Defense Department, from selling anything to Anthropic. So selling cloud computers, selling computer chips. This would have essentially destroyed Anthropic as a company. This is just flatly illegal. I don't think there's any argument whatsoever for this. There's nothing in any of the statutes that the Defense Department has cited to support this authority. And in fact, when Congress decided to impose a similar kind of secondary boycott against the Chinese telecommunications companies Huawei and ZTE, it did so in a separate provision of the 2019 NDAA, which again is more evidence that if Congress wants to give the executive branch or wants to impose a secondary boycott on a company, it knows how to do so, and it did not do so in the more generally worded statutes that the Defense Department is citing. Now, since then, it appears to be that the Defense Department has walked back on this. The letters that Anthropic appears to have received do not contain this kind of expansive secondary boycott. And other companies like Microsoft and Google have actually confirmed that their understanding of the official designation is that it does not, again, have the secondary boycott effect. That's obviously good news for Anthropic. We'll see if that changes, whether or not the courts are more or less willing to give Anthropic the sort of preliminary relief that they're requesting now that this litigation is not quite as existential for Anthropic as it first appeared to be. But it's still not clear what the government is doing. Anthropic has reported that the government has been going to Anthropic's enterprise clients and encouraging them not to do any business with Anthropic at all. So I think the secondary boycott is still a potentially live issue. And to the extent that the government is pursuing that, I don't know. I can't imagine a single good faith argument for what they're doing. So there's that. There is still the kind of primary supply chain risk designation. The government is correct that under the applicable laws, which there's a Title 10 authority, Title 10 USC 3252. This was enacted in the 2011 NDAA and then made permanent in the 2018 or 2019 NDAA. And then there's another authority that the government is using. This, by the way, is why there are two lawsuits. The 3252 authority is being challenged in California, whereas the other authority, which is under Title 43, part of the Federal Acquisition Supply Chain Security Act, the inelegantly acronymed FASCSA, that was passed in 2019, I believe, that has to be challenged in the DC Circuit. So that's why there are these two lawsuits. Under those authorities, if the government legitimately labels Anthropic or anyone a supply chain risk, in fact, the government can, and this makes sense if you think about what a supply chain risk is, prohibit that company from participating either as a prime or a subcontractor in government contracts. The problem for the government here is that Anthropic is not a supply chain risk, as those statutes understand that term. So if you read the legislative history, if you understand the context that was happening in the 2010s, it's pretty clear that what Congress was trying to do was deal with the increasingly globalized supply chain, information technology supply chain, and in particular, companies like Huawei and ZTE on the Chinese side, and then Kaspersky, for example, the quote-unquote cybersecurity company on the Russian side. And it's pretty clear that that's what they were trying to prevent, and in particular, the preventing of foreign companies subverting or manipulating or secretly introducing flaws into government systems. Anthropic is, of course, neither of those things. It is an American company. It does have some passive foreign investors, but it is an American company, and it is not trying to do any of this secretly. The red lines that it has been advocating for were part of a contract negotiation, one that, again, it's worth pointing out, this Defense Department signed last summer. Of course, that is separate from whether the department should or should not enter into such an agreement with the company. But this is, I think, a far cry from what these statutes anticipated. In addition, even if these statutes anticipated an American company being included, Anthropic is just not a supply chain risk. And we know that because the government is trying to argue three things simultaneously. One, that Anthropic is so valuable that the government occasionally threatens to use the Defense Production Act to force Anthropic to sell Claude to it. Second, Anthropic is so important and safe that it is currently being used in the war against Iran. And third, Anthropic is so dangerous that it is a supply chain risk and has to be excised from government systems. You cannot argue all three of those things at the same time. So on the legal basis, the statutory arguments don't line up. And then finally, and then I'll stop talking, Anthropic makes a First Amendment argument that I think is interesting and where there is some truth to it, but I think we have to be quite careful with it. To the extent that the government is retaliating against Anthropic for its public statements, and in particular for the government's perception that, as Donald Trump stated in his Truth Social post last week, Anthropic is, all caps, woke, then yes, I think there's certainly a plausible First Amendment claim. But to the extent that Anthropic, and then in particular some of the amici, ACLU, FIRE, I think Cato, and I think EFF have argued, Anthropic has a First Amendment right, or rather, Anthropic's training of Claude, including for products sold to the government, is itself First Amendment expressive activity protected by the First Amendment. I think that's actually not a good argument, and I think that has a lot of dangers. I'm happy to get into that in the Q&A. But I think I'm very doubtful that any of the courts will reach the First Amendment argument. I think the statutory problems with what the government is doing are so obvious that this will all be resolved on statutory grounds.
Great. Thanks, Alan. Before we get to Quinn, maybe I'll turn to Jennifer and have her talk, because I suspect she may deal with some of the same issues that Alan was talking about.
Yeah, although I'm now going to explain why you should actually really care about the First Amendment rights that Cato and others invoke in the briefs. As was mentioned, my name is Jennifer Huddleston. I'm a senior fellow in technology policy here at the Cato Institute. As was kind of referenced, Cato joined a brief including the Foundation for Individual Rights and Expression and some other groups, including Chamber of Progress and many more, and a few more focused on the speech rights at play in this issue. And I think that's what's really important to think about is why this is a much bigger issue than just a mere procurement dispute. There certainly are various elements at play here about the specifics that this is being done over Pentagon procurement, but if it was simply about the procurement of AI, we could have seen much more simple solutions come into play, including something like canceling the contract. However, there are several different topics that I think should be paid attention to, regardless of how you feel about Anthropic's red lines and regardless about how you feel about AI in general. And that is, to me, what's at the heart of this issue is when can the government pressure a private company to change its product to serve purposes the government wants, but that the company doesn't want to do? That to me does go to basic expressive rights. The same way that we wouldn't expect the government to be able to tell a newspaper what content it must publish or must not publish, or tell a store how to run its business. We should, even if the business, even if the government sometimes purchases products from those, we would or carries that newspaper in its offices, we shouldn't expect them to be able to tell AI companies how to operate their products just because the government may also want to use them. Additionally, the red lines that were drawn here are some of the key civil liberty questions when it comes to AI policy that we're seeing currently be faced, and that there does need to be a broader conversation around what, if any, policy guardrails are there. There are many opportunities to use this technology beneficially in the government, whether it's keeping a confidential meeting more confidential by having an AI note taker rather than a human note taker, whether it's helping constituents connect with their services to be able to receive the benefits that they're eligible for. But the problem is that given the serious civil rights and civil liberties concerns raised by things like the threat of mass surveillance or lethal autonomous weapons, many Americans are concerned about what happens if the government has access to this technology. One way to potentially resolve this is to focus on the particular harms that we're concerned about, in this case, mass surveillance or autonomous lethal weapons, and seek to provide guardrails that restrain the government's own use of technology for those potentially concerning purposes. Now, that's not to say that the guardrails are going to be perfect and stop all potential abuses, but they should at least provide greater legal certainty that this otherwise beneficial technology isn't being abused to compromise civil rights and civil liberties here in the US. This seems to be an area where we could see guidance at both a state and a federal level, but that guidance needs to ideally come from Congress. When it comes to a lot of this dispute, it comes down to the interpretation of lawfully allowed. It seems like some are more comfortable with the idea that those things are already illegal and therefore removing the safeguards would have had fewer risks. Whereas Anthropic, being a company that highly values its constitution of its Claude model, felt that to do so would risk potentially compromising what has distinguished it in the market, and as a result has faced this retaliation. I think there's a second element to consider in this discussion too, which is what signal does this send to governments around the world when it comes to their interaction with AI companies? This is the American government effectively using its power to go after an American company and effectively blacklisting it from potentially doing business in a number of ways that make its market viability much more limited. We know that there are countries around the world that would love to force American companies to change their values to serve those governments' ideals when it comes to whether it's surveillance or whether it's towards other potential manipulation or abuse of civil rights and civil liberties. This would be an example that those who want American companies abroad to change their standards to do business in those countries could point to and say, well, the US government did it to you. Why can't we make the same demands? And so I think we also have to consider what it means in terms of the precedent it sets, not only in terms of legal precedent here in the US, if this is allowed to stand, but what precedent it would set globally when it comes to the interactions of America's leading AI companies with governments around the world.
Great. Thanks, Jennifer. Now, Quinn, why don't you jump in and talk a little bit about some of the ramifications outside the DoD context?
Yeah, thanks, Samir. We've sort of started to touch on this, but the Trump administration's actions against Anthropic have already had effects well outside of the defense context. So I'm going to kind of give a brief overview of what those have been so far and what some of those, the impacts of those actions are. So in his initial posting to Truth Social, the president explicitly directed every federal agency, not just DoD, to immediately cease use of Anthropic systems. This directive had very quick repercussions. On the very same day as that initial post, the General Services Administration, GSA, publicly announced that it was dropping Anthropic from USAI.gov, which is a platform federal agencies can use to take advantage of low and no cost deals with AI developers, as well as the multiple award schedule, which provides federal, state, and local governments with access to commercial products at discounted prices. The impacts within federal agencies, though, did not stop here. Subsequently, many major agencies publicly announced that they would stop their use of Claude. To date, this includes GSA, like I just said, Department of State, Health and Human Services, Treasury, Federal Housing Finance Agency, OPM, NASA, the International Trade Administration, and the Secret Service. On top of what has come to light through public reporting and statements, at least 10 federal agencies, including several of those that have subsequently announced their termination of Claude, just in the last few months reported use of Claude and other tools powered by Claude as part of their 2025 AI use case inventories for tasks like searching agency information systems, drafting documents, and generating code. The most recent development, though, within this sort of batch of things is that GSA has some draft terms and conditions for federal contracts and solicitations for AI systems that were recently made public by Politico. These draft terms would both concretize many of the requirements from the Woke AI executive order in federal contracts and would implement the key portion of the Anthropic contract that is at stake right now, requiring that any agency is able to use an AI system for any, quote, lawful purposes as a required standard clause for all future government contracts and solicitations for AI systems. To be clear, this development, GSA's terms and conditions, if they are finalized, will have ramifications far beyond Anthropic and companies that integrate or use Anthropic, impacting every single federal contract for AI systems. This is particularly notable because of the current lack of clarity in the draft terms, particularly provisions that require, and I'm quoting, AI systems must not refuse to produce data outputs or conduct analyses based on the contractors or service providers' discretionary policies, while at the same time stating, quote, this requirement must not be construed to require retraining of the model or alteration of model weights. These facially seem to be in tension with one another, so I think this should raise a significant question of how will this actually be actualized in systems if this is now a standard contract term. Really, the kind of thing I want to hammer home here, though, is this is adding to an already chaotic policy environment for both federal agencies seeking to use AI and for vendors looking to work with the federal government. Agencies are already working with fewer personnel and constrained resources, making it even harder for them to responsibly procure and deploy AI tools. In fact, the current developments have already led several agencies to scramble in order to adapt their systems and processes without Claude. The IRS, for example, is now searching for an alternative AI model for collecting owed taxes after ceasing use of Claude when it was their plan to use that as the primary tool for doing so. And the State Department had to offload Claude as the base model supporting the agency's flagship state chat chatbot, having to look for an alternative system as the base model for that tool. This is also creating significant uncertainty for vendors as they're trying to navigate what GSA's draft terms will mean for their products and services. And in particular, I just want to highlight a couple provisions here beyond what I just discussed, which is, the use of AI systems for unlawful purposes. The GSA's draft terms and conditions also have provisions requiring a quote unquote eyes off data handling procedures that restrict human review of government data. As well as requirements for truthful, quote unquote, truthful and neutral outputs that, quote, do not manipulate responses in favor of ideological dogmas such as diversity, equity, and inclusion. These requirements, though, remain unclear and without straightforward technical or policy pathways for vendors to actually implement these. So really, I think, and Paul's comments were highlighting this in particular, this risks confusing decades-long standardized procurement processes and rules. And these have existed to shelter public dollars from political whims and to make a fair playing field for vendors. And without some of these guardrails in place, our tax dollars are vulnerable to misuse, waste, and corruption. On top of that, these new GSA draft terms and conditions are really a detriment to advancing key safeguards in AI systems. Um, the net effect here is really going to be the worst of both worlds, where on the one hand, vendors will be forced to remove even more safeguards, and responsible companies will be scared away from working with the government at all. I'll stop there.
Great. Thanks, Quinn. We're going to turn in a moment to our final opening statement, but then we're going to open this up for discussion, audience questions, and the like. So folks should be thinking about what questions they want to pose and to our speakers or otherwise. But before we do that, Jake Laperouk is going to close us out with the opening statements.
Great, thanks so much. So I'm going to focus on one of the two red lines that sort of kicked this hornet's nest, which is the one against domestic mass surveillance, and kind of try to break that down a bit further. It's really important to look at this not as in the abstract or as a sort of far off theoretical hypothetical, but rather as a real and concrete type of action that can and currently does occur. And specifically, the issue in focus here, based on reporting, appears to be the data broker loophole. So what is the data broker loophole? This is the ability of government agencies, both law enforcement and intelligence agencies, as well as the military, to buy data and data sets that would normally require court approval. This can be information such as web browsing activities, communications metadata, cell phone location data, transaction and purchase records, and so on, all of which require either warrant standards or court approval standards. And additionally, the government not only buys these forms of data, but buys them in bulk, even when bulk collection was banned in FISA reforms that occurred back in 2015, aka this is mass surveillance. So in terms of the Department of Defense and data purchases, the military and military intelligence agencies like the NSA exploit the data broker loophole and do so at scale. Typically, when the military or intelligence agencies are going to buy data sets, they're going to not aim at domestic dragnets, but they do so in a very broad manner. They will purchase large data sets that can contain millions, tens of millions of individuals' records. And when that happens, it's inevitable that you're going to pick up US person data. So, for example, we had some collection sets of a Muslim prayer app that were reported on that involved roughly 100 million users. If you take that and even take like a small percentage, like 1-2%, if those are Americans, you're still collecting data on millions of Americans through single purchase sets. The Office of Director of National Intelligence even has a full framework setting out rules for use of US person data through commercial data purchases, which I'm dropping into the chat if you want to either look at it in full or some fact sheets that are included on it. And that's something that privacy groups like CDT have viewed as, while good that there is a framework for it, woefully insufficient in terms of the level of protection that is applied. So thinking about this loophole and this type of surveillance in the context of AI, it's very easy to imagine serious risks and potential harms from using AI on these databases. Because of the scale, AI can allow for data mining that's previously not possible. It can allow for pattern detection, for detection of abnormalities from standardized patterns. This is something we see in the law enforcement and immigration enforcement context quite frequently, and for network mapping as well. And it's also easy to see how this could seep into domestic activities, such as the vast amount of surveillance activities that are conducted by the intelligence community through military-run border zones that have become increasingly common, and through any future military deployment in cities. Now, in terms of the lawfulness of this activity, the government treats the data broker loophole as lawful. Unfortunately, we do not have insights into their legal analysis on this. Those have been largely kept secret. But it's key to note that in the context of the administration's position regarding AI agreements, such as the one at issue here, that they should be able to engage in all lawful uses of the technology or any lawful uses of the technology, that this type of collection of commercially available data and use of commercially available data is treated as a lawful use. So this is a type of domestic mass surveillance that is not just theoretically possible, but is actively engaged right now by the government. How do we respond to this? This is something that CDT and a number of other groups have tried to take on by closing the data broker loophole. There's a piece of legislation, the Fourth Women's Not for Sale Act, that's been enacted in several, or sorry, not enacted, we wish enacted, introduced in several Congresses in the past, and is something that we think is likely to come up in the pending FISA debate, although there's an increasing chance that that entire debate is going to be punted for an 18-month period. Added support on this measure to keep it as a live content, as a live item for potential reform will be critical.